Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer by watching our videos. You agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are here to unpack the ever-changing world of immigration with expert insights and a lively discussion. Whether you're navigating the complex maze of visas or just curious about immigration trends, you have come to the right place. Today's topic, EB-2 NIW visas. Are USCIS making it harder to get it approved in 2024? Buckle up because we are diving deep into this hot button issue. And trust me, we have got the dream team to break it down. Yes, but first, let's give a warm welcome to our wonderful audience, whether you're watching us live or catching the replay. Thank you for tuning in. Be sure to stick around because this episode is packed with valuable insights and maybe a sprinkle of humor too. And don't forget to drop your questions in the comments. And yes, after we get answers from our dream team, we will be asking your questions to them. So now, without any further ado, let's meet the dream team, our incredible guest for today's show. First up, we have Rob Melvin, a 26-year veteran in the legal arena and a licensed attorney by the Texas Supreme Court. Rob's journey has taken him from litigating in Texas courts to serving as a Foreign Service Officer for the U.S. Department of State, where he held consular commissions under 3 U.S. presidents and adjudicated over 9,000 visas. From diplomatic scrutiny trainings to managing high-profile visits from the likes of Hillary Clinton and Mike Pompeo, Rob has done it all. Today, he's a powerhouse in employment, business, and investment-based immigration. So, Rob, welcome to the show.
Happy to be here. Thank you for the invite. And we're humbled to be on your show and thankful for the opportunity.
Of course, it's a pleasure having you on the show. And after Rob, everyone, let's meet our second guest, Philip Rodriguez, who might just be the Clark Kent to Rob's Bruce Wayne. Philip is a partner at Rodriguez PLLC and brings 13 years of stellar experience to the table. He's represented clients globally, tackling everything from family-based petitions to removal proceedings with finesse. With a Juris Doctor from St. Mary's University and a knack for delivering personalized legal solutions, Philip is a force to be reckoned with. Philip, we are so glad to have you here. Thank you so much for joining us today.
Yes, thank you very much, Rajni. It's a pleasure to be here.
Well, thank you so much to Rob and Philip. And guys, let's get into today's topic. The topic, like I said, is the EB-2 NIW visas. Yes, EB-2 National Interest Waiver visas. With the USCIS rolling out the new guidelines, are these coveted visas becoming harder to secure? Are we entering a new era of red tape? Or is this just a bump in the road? Let's find it out from Rob and Philip. So now, without any further ado, Rob, I would like to come to you first. You know, while I was introducing you, you have this 26 years of experience. I might have accidentally called you a 26-year-old, which you also look like, the both of you.
My wife's in the witches.
but Rob, also I would like to know from you, recently the US presidential elections results were out and the Trump is back with his very aggressive team and his administration, because every day he's giving us a shocker with picking those controversial candidates and making it harder for immigrants to actually think that is it going to be possible for them to get into the US now, or is it going to be more difficult? How is the situation going to be? So it's so chaotic and it's all over the place right now. So were you happy with the results? Let's first come to you and then we can see how Philip felt about it.
Okay, well, I mean, to my knowledge, I don't consider this bad news at all, especially for Indian nationals. It may be bad news for people from the Western Hemisphere that have come over irregularly, because I could see removal practices being very more difficult. But there's some things that I think that maybe your audience should keep an eye. I mean, listen, there's 3 people close to Trump now that have his ear and will have it regularly. You have the second lady, Usha Vance. You got Vivek Ramaswamy, and then you have Kash Patel. All 3 of those people are going to be talking to him every day. And believe me, they've been in the U.S. for a long time. They know the plight of the Indian retrogressed visas and the problems that people have been having coming from India to here. As for like the comment on the adjudications becoming more difficult, we've actually seen in our practice, 2023 was the dream years. Those were the golden years for the EB-2 NIW. We were shooting 3-point shots, getting approval without a lot of pushback. 2024 actually turned into a bit of a quagmire. That I don't know what happened. I don't know if USCIS was pushing back against the administration because of all of the irregular immigration coming in, maybe as kind of I don't know, retribution, if you will. But we have seen in 2024 more pushback, more stringent, more new requirements, almost pre-Danisar analysis to the EB-2 NIW than we did in 2023. So I have high hopes for 2025 for the Indian national population. They're some of the smartest applicants that we have, the most highly educated, the most qualified. And I mean, in my opinion, everybody's got an opinion. I think Trump and his team are going to be looking for people of that caliber that are going to come in and kind of lift the boat of the U.S. economy with especially STEM, financial investment, those types of visas coming in. So I'm actually super hopeful that 2024 will go away for the EB-2 NIWs because it's been a rough year. And that 2025, once things start rolling, we're going to see a better improvement. Again, that's if USCIS, each agency kind of has its own culture, does its own thing. I worked for state under Trump. They pretty much ignored Trump and just kept doing their own thing. I mean, of course, they had to do some policy and economic and political moves that he made them do. But I was in the consular section and they just kind of, they're like, yeah, whatever. So I don't know. I don't know if that is too much information or answers the question, but I think that we're going to see, I hope that we're going to see an improvement, especially in the fields of STEM and cases where we can make a really good argument that addressing a very specific national interest for the United States.
Philip, what about you? Because, I mean, Rob said that it's going to be, with Trump coming back with his team, it's going to be good for the market and good for the economy. And, we have seen that Trump is already talking about putting those percentage of tariffs on those countries, especially Canada. And, recently Canada's Prime Minister Justin Trudeau, he met President Trump, and he actually joked with him for becoming, Canada becoming the 51st state of and merging into the US. And he said, you are more than welcome to become, you will not be the Prime Minister, but then you can become the governor of the 51st state. How about that? So, he has really scared Canada. And, there are talks about putting 100% tariffs on the BRICS countries if they think about, getting another, if they are getting those, instead of, if they will give priority to some other, anything else apart from dollar. So what do you think? Because, there are so many talks about that. So how do you see? Do you think it's going to be good?
Well, yeah, I agree with Rob in terms of the EB-2 NIW visa, right? Because that visa is for people who can show that their work is in the national interest of the United States. And touching on what Rob mentioned, how we have seen, so under a Trump administration, we may see a stricter interpretation of USCIS policies, but I don't necessarily think that that's because it's the Trump administration. If we go back, let's think about DANISAR, which is the guiding framework for an EB-2 NIW petition. DANISAR became law in 2016 under Barack Obama. And since then, and think about that, 2016, that's only 8 years ago. So that framework hasn't been in effect for very long. Prior to DANISAR, we had a much stricter framework for EB-2 NIW under the New York State Department of Transportation. And that went into effect, I believe it was 1998. But the point is, we may see stricter interpretations of USCIS policies under Trump. I don't necessarily think it's a function of Trump. I think we'll get into this a little bit later, but I think it's more a function of the fact that a lot of people are learning about EB-2 NIW now, and a lot of people are filing those types of applications. It's become highly competitive, and that is why USCIS has to do a better job of sifting through all of these applications and finding out which ones are truly in the national interest of the United States. And I think what we're probably going to see is the industries that will be favored under a Trump administration are going to be manufacturing, I think national security, and I think technology. Which may not be good news for those who would like to apply under the humanities or the arts. They may have higher hurdles to jump.
Okay. Well, thank you so much to the both of you for that amazing answer, and also for sharing your point of view. But with this, Philip, I would also like to know from you that what do you think? Do you think that USCIS gets influenced by who takes the office? Let's suppose, because earlier it was the Biden administration and now it's going to be Trump administration. So do you think they make plans and they make the policy changes or whatever updates that they give in? It somewhere gets influenced by who takes the office?
I think the leadership does have an effect on policy directives and adjudication standards. However, I don't think it's necessarily going to be a complete shift, right? I mean, USCIS is a relatively large organization. It has its own culture, right? So because a new leader comes into office who may have a differing opinion on policy, sure. I think it is fair to say that might influence some adjudication standards. However, I don't think that it's necessarily going to just make it impossible for people applying for EB-2 NIW. As I mentioned, what we may see is a shift in the industries that are favored by this administration, because it's no surprise. Trump and his team have come out and said that they want manufacturing in the U.S., technology, and national security. And so I think we may just see a shift in the types of industries that are favored. Would you agree?
Rob, what about you? What do you think?
Definitely. I mean, it does depend who's put in charge of DHS, and then it flows down from there. And then they'll have the director of USCIS and the deputy director, and they will push downwards. But I've been inside the belly of the beast. I work for state, and I know they do have their own corporate cultures. I think, in my opinion, they're going to be more in line with, if these predictions are right, with the emphasis of Trump and his team continuing to be on manufacturing, tech, STEM, anything like that. I think it will influence the adjudicators in favor of pleasing their bosses. These people are all bureaucrats. I was a bureaucrat, right? So what's the one big fear to a bureaucrat? It's your career. And what is that? That's your review at the end of the year, okay? these are all civil servants. In fact, they're all graded on a G scale, which means you don't just get promoted. You actually have to, if you want a higher, better job, you want more pay, you have to apply for a higher scale, a GS 14 instead of a 13, right? Mm-hmm. So the only way that they're going to do that is they're going to have to show that they have a track record of pleasing their bosses. If their bosses are telling them, look, Trump says X, we need to go in this direction, and that's the order they're getting from the top, they're going to need to move that way if they want to eventually secure a higher level government service job and keep continuing on. There's some that'll be perfectly happily being a GS-12 and couldn't care less and just want to draw their check, do their 40 hours and build their pension, right? Mm-hmm. But there's some go-getters, and the hustlers are going to want to see, they're going to want to comply. So I think it's going to be a great year for EB-2 NIW. 2024 has been a challenge for us in our practice, and I know it's not specific to us because we're members of ALA, and we have our distros with thousands of immigration attorneys all over the United States, and we constantly keep an eye on it because it's one of our areas of emphasis is employment, business, and investment, immigration. So we really keep a close eye. And I think it's going to influence them. Yes. I think there's a misperception that it has as much influence as it actually does, but that's just my experience in working for state. And I have a lot of friends at USCIS and DHS, so I kind of keep my thumb on that pulse as well.
Okay. So, but then, Rob, when you say influence, do you think that influence is going to be good or is it going to be bad?
I think for the Indian national community, it's going to be fantastic. Mm-hmm. It's one of the smarter applicant pools, one of the more ambitious applicant pools or countries, and just more qualified, and they're more hustlers. I mean, they just are go-getters. And I think that's going to be what the policy that they're going to want to be pushing downstream at DHS, down to USCIS and everybody else, to the adjudicators, is look, we're kind of changing the way we look at immigration. We want to do, as you've mentioned before, kind of a merit-based system. The family system will always be there, but they want to improve our economy. And the only way to really do that is to do a brain drain away from other countries. And India's got plenty of brain drain power to provide to the U.S. I think it's going to be good for India.
Okay. But then what do you think about the visa? I've still not delved into our questions that actually we have prepared for you, but I'm still coming up with the follow-ups. But then I would like to know from you, Rob and Philip, that then what about the wait times that India actually sees, from whenever the visa bulletin comes, the processing times, the wait times for India specifically are very long. So why do you think that happens? Philip, I would like to start from you.
Well, the reason you see these retrogressed visas and the wait times is because of the per country caps on green cards. It's a 7% cap on green cards from any country, and you have a lot of applicants from India. 7%, I believe that works out to around 9,000 visas, 9,500, something like that per year. Mm-hmm. But because we have so many applicants, that's what leads to the retrogression. And something that I think maybe we could see, there's legislation pending right now to remove the caps on green cards. And so that's something that we could see help with these retrogressed visas. But that's a great point that you bring up. And that is the biggest India-specific challenge, is that we're seeing retrogression decades.
11 years to visa availability and 12 to adjust.
Yes.
Wow.
Yeah, so that's a very good point. And what you do in that instance, and what we advise our clients is, well, let's look for, if that's what you're going for, let's look for other ways to keep you in the U.S. lawfully, keep you working. Let's look for other options, because the EB-2 NIW visa is just one tool in our toolbox, just one. We have so many available options out there. So that is key when it comes to an analysis for an Indian national who is seeking the EB-2 NIW.
Okay. And Ram, okay. So now I would like to actually ask from you that, but do you think in 2024, I mean, it's just about to end and 2025 is about to start, right? So do you think in 2025, EB-2 NIW is still going to be that golden ticket, you know, for the immigrants?
Yeah, I mean, so here's what's happened, and Phil can put in his 2 cents. I think the H-1B program, the CAP H-1B program, has become such a disaster over the last 2 cycles that everybody kind of flooded from H-1B over to EB-2 NIW. And I think that's what's caused the problems in 2024. So what I would like to see happen, what I hope to see happen, is they actually fix the H-1B, because people have been gaming the H-1B so badly that the percentage of the lottery winners, I think, was 10% last year and 17% the year before. So people are opting for other ways. So they're going to the EB-2 NIW. EB-2 NIW is definitely the golden ticket. I mean, same with EB-1, but you got to have a good package, you got to have a good plan, and you have to be qualified. You know, it's not the golden ticket for everybody. You know, we usually can knock out the first part relatively easy to the EB-2 analysis. It's when you get into the national interest NIW analysis, substantial merit, they usually just give it away, because the ones we're throwing up there, we're not throwing up to open up a McDonald's restaurant, right? We're opening, you know, we're doing naval inspections and maintenance on cargo ships, oil platforms, logistics and supply chain cases, warehousing and distribution. I mean, those types of cases, you're not going to just get an EB-2 NIW for any reason. But we usually, substantial merit, usually they just kind of give that one away, because it's easy to articulate how something might be in the substantial merit. So then there's 3 prongs, but there's actually 4, because the first one has 2. Then you get to the national importance. This is the one where they're currently really sticking it to applicants. Okay, so what? Your program, your subject matter expert has substantial merit. So what? How is what you're going to do going to be in the national interest? We have to now lay out the breadcrumbs piece by piece from their business plan, from their proposal, to the substantial merit piece, and connect the dots very explicitly for the applicants. And then you drop down to is well-positioned. You know, before, well-positioned was kind of like, well, they've got a master's or they've got a good professional history. Now they want more. They're even asking for kind of like, okay, you're going to do this. Do you have the financial wherewithal? Where are you going to get those funds? Do you have any kind of track record in doing this particular endeavor? So they're making that one a little bit harder, but that one is usually we're able to overcome relatively easily. But then they jump to the last one, which is the most nebulous of them all, whether on balance it would be in the interest of the U.S. government to waive the labor certification. Well, what the heck does that mean? I mean, I thought we answered that in the first three questions, but basically we're making the argument that this is so necessary that we need to just move away the year and a half labor cert process, which is currently just getting longer and longer and longer, and just get this person in. Let's get him in. Let's get him going. Let's get him improving the country. You know, whenever there's a national crisis that or an international crisis that we can link to and cling on to, that's related to our client's deal, we do that to, and try to file as quick as we can to, to hit that particular piece. Like, we need this person in now. So anyway, I don't know if that answered your question, whether it's the golden ticket. It's not for everybody.
Yeah.
Not for everybody. It's not the Willy Wonka chocolate bar. You have to actually, come in with merit in this deal. When we make you look as good as you can possibly look, but you have to have some juice behind you as well.
Right. I mean, if this is not the golden ticket, maybe US can also come up with, golden visas like Dubai or maybe, other countries. They offer golden visas, right? So maybe US can come up with something like that. Right, Portugal. So, okay, coming back to my questions, Rob, I would also like to know from you that with President Trump now returning to the office, what do you think? What are the risks of reversing the more lenient policies recently adopted by USCIS regarding EB-2 NIW applications? And how do you think that this might impact applications who already have begun their petitions?
Well, first of all, the more lenient policies, maybe that applied in 2023. We are not seeing that in 2024. So I think the question may kind of presume an erroneous answer. We think they're stricter now than they have been for the last couple of years. Although on paper they might be lenient, in as applied, they're much stricter. So everybody who's already in play, they're going to get adjudicated under the standards when it's on that person's desk. So whatever the policies are at that time, there's not going to be any kind of grandfathered in, because DONASAR is the standard, right? And has been since, what'd you say?
2016.
So that standard hasn't changed. The way they implement the standard, that's changed. Couple things that have been problematic or troubling to us that we've seen is, we've read a lot of articles and tracked a lot of things that it looks like they're adjudicating a lot using AI tools, which everybody uses AI tools now, right? Problem is, I used to work for the government and I know what kind of software they usually get. And let's just say it's not ChatGPT 4.6 or whatever, we're seeing RFEs that are misspelled, incomplete sentences, jumbled garble, repeat boilerplate clauses, just that maybe don't even apply to the same case or the same subject matter. That's a problem. We also saw the recent article did. They've subcontracted a lot of their work to Chase. So here you have civilians adjudicating these cases. I can't say for sure that they're adjudicating EB-2 NIWs, but by the RFEs we've received, it wouldn't shock me, because it seems like the person making the decision doesn't even know what the heck they're talking about for the case.
Yeah, it's Rob brings up. So a request for evidence, just for viewers that don't know what that is, that's what USCIS sends to us after they've reviewed our initial submission, our initial visa submission. If they would like to see more evidence about our application, they'll send us a request for evidence. And it is no exaggeration to say that we have seen, I would say, of the RFEs that we see, about 50 to 75%, they literally make no sense. And just like Rob pointed out, grammatical errors throughout, requesting evidence that was included with your initial submission. So on the topic of the AI and RFEs, I totally agree with Rob. And then as far as going back to the leniencies, I also agree with Rob. In our practice, we don't see any leniency. These applications, this visa is a very tough visa to get approved. Thankfully, we've had great success with that. One item maybe that could be considered a leniency is premium processing, and that may have been a leniency early on, but now you ask almost any immigration attorney who's in this area who handles these types of cases, and they will tell you, maybe it's not such a good idea to file premium processing, because that's almost like you're putting a target on that application, and it may draw greater scrutiny from USCIS. I would say in our practice we see that more likely than not. Certain applications that are just stellar applications, maybe they could benefit from premium processing, but again, what we see frequently is that premium processing, which could be considered a leniency, wasn't so lenient.
Not only, I mean, why would you pay $2,800 and probably some extra attorney's fees to do premium processing when your visa category is retrogressed by 11 years? So you're going to get a yes much quicker. People were doing that because of the elections. But now, I mean, we recommend our clients don't even utilize it at all because of the negativity. We think it's like a boogeyman out there that if you use premium processing, you're more likely to get a strong RFE, and they're really going to come at you because it's a war of attrition, right? A lot of people don't respond to the RFE on time, or it's much more work or much more cost. They just go away. So that's just that many less petitions that they have to adjudicate. But if there's no, like, it would be very difficult for me to imagine the benefit of a premium processing especially to an Indian national, a Chinese national, a Mexican national, any of the ones, Philippines, that are very retrogressed. Why do you care when you get your approval? Because you still got a long wait before you can do anything else.
Wow. Okay. As they say, nothing comes easy, and especially, if it is something really good. So I think those EB-2 applicants, will really have to buckle up, and maybe they can start binge watching some stress management videos. How about that, Rob and Philip? So, but Philip, I would like to come to you and ask you, but do you think that with this, do you think there will be rush among applicants to file their petitions before, any anticipated policy changes? Because people, especially now that Trump has won, because they are every day thinking that some or the other policy change might happen. So do you think that there will be rush among applicants? And if people are considering that, what advice would you like to give them?
Well, I can tell you that the short answer is yes. And I say that because we've seen that. We have seen a rush in applicants trying to get their applications in before the change in the administration. We have had any number of applications, but also the EB-2 NIW. We have people calling us every week, 10 to 15 possibly calling us a week, trying to get this EB-2 NIW petition, trying to get it filed. So we do see a rush, and we're seeing a rush from all countries in all areas. People want to come to the US. And so what I would advise anyone who is in that position that would want to get their application in before this current administration, I'd say, talk to a lawyer as quickly as possible. Give us or someone else a call. However, be realistic about your timeline, because in all likelihood, the EB-2 NIW, because as we've outlined, it is a difficult visa to apply for and come up with all the evidence. So it's not necessarily going to be filed before the new administration begins. So just be realistic about your timeline. And also, again, I know there may be some anxiety out there about the change, but come on, we change every 4 years almost. Whether it's the same political party or not, there's change in the administration every 4 years or so, and we've seen that in our practice, in Rob's employment with the government, in my practice in immigration law, in both of our practices. Change is going to come no matter what. You just have to select a team that is prepared to handle that change.
Right. So I think we are going to see a lot of people more than the attorney's office. They are possibly going to go to the astrologer's offices now, especially for these 4 years. Rob, I would like to come to you and ask you that what do you think? What do you think about the Muslim majority countries? How are people dealing from those countries? And are you also getting calls from those countries? Because Trump with Project 2025, I mean, Trump and his administration are thinking of putting a ban in the Muslim majority countries, travel ban. So if you can please tell us about that too.
Yeah, I mean, we haven't seen a lot of that in our practice. I've seen zero. We both take calls and we usually interview the clients together. So we really haven't seen that as an impact at all. We have many clients from Muslim countries and it's like the boogeyman effect. It's like that's something that may never happen. Maybe it will happen. If you're that afraid of it happening, then get in. Let's get your case filed and go. But I can't predict with any certainty that that's going to happen again.
Yeah, we don't. On the topic of the boogeyman approach, we cannot advise our clients based that are rooted in fear. Right? We try not to use fear. We do not use fear to influence the way we handle our practice. Again, change comes every 4 years, and sometimes faster, depending on what the judicial system is doing and what new case law is coming out. I mean, really, as Rob mentioned, we're members of the American Immigration Lawyers Association. Mm-hmm. It's over 1,000 immigration lawyers across the United States. And we are on listservs and distribution channels and emails. And so we follow this all day, every day. And I mean, new cases come out every day, every week. You get 3 or 4 or 5 new cases that change the law. I think the judicial system, it's on its track. It's going the way it's going to go. And I don't think that there's necessarily major influences on who's in charge.
Okay. Thank you so much again for answering the question, Rob and Philip. Now, I would like to come to you again, Rob, and I would like to ask from you, given the historical context of, the heightened security, scrutiny during Trump's first term. So do you anticipate that the USCIS will revert to a more stringent interpretation of national interest? And if so, what evidences might applicants need to provide to counteract this?
Well, I sure hope they don't get any more strict than they already are, because they're at a pretty high level, and Trump's not even in office, and they've been at that level all year this year. So, like I said, the strategy is you have to have a strong business plan. So you need a professional business planner, right? And they're going to take all of your strengths and all of your history, and then articulate the national interest. But now we can't just say, okay, great, this person is in cybersecurity and has a good professional background. This is a national interest. We're getting hacked by Iran and China and North Korea. So that's a good match. Now we have to show this person is cybersecurity. The first 3 months, they're going to do this to implement it. The second second quarter of the year, they're going to tie into these certain key areas of the economy or of the national landscape, and then these are going to be the results, right? So you really have to, more than ever before, for national interest, just lay down a crumb trail, paint a picture exactly how what you're going to do is going to help each aspect. It's very easy to articulate a national interest, but the way that they're saying national interest now is show me how your person is going to hit that national interest. It doesn't matter that, we've had the Panama Canal problems and problems in the Suez Canal. I want to know how your naval engineer is going to actually fix those problems. So then you've gone from just saying, hey, I've got a great naval engineer and I've got there's huge problems that are causing supply chain worldwide, massive damage. Now you got to say, this is what my naval engineer is going to do. He's going to go over to XYZ spot, address, ABC issue. It's going to result in DEF result. I mean, it's a lot more work and a lot more intensity. And quite actually, as a law firm, we have to raise our rates a little bit to correspond with the amount of time that we're having to put in these. I mean, because these are getting to be, much more intense cases than they were before already. Again, I hope in 25 is that what we're presuming is going to happen is going to actually be the opposite. I want to see, like with Elon Musk involved and the emphasis on STEM, that they're going to be seeing, hey, this candidate's great. We know what the national interest is. Approve this, this petition. I can't say that's going to happen. Those are my hopes, but it sure as heck can't get much harder than it is right now. And we're under Biden. We're under the Democratic Party. This year has been awful for national interest. So, I don't see how it gets much harder than it's been. Philip might have a different opinion, but
no, I agree. I think what we're seeing with national interest and heightened scrutiny has been coming down the pipe for a while now. And what we see is a focus more on immediate economic and job impact rather than long-term contributions. So part of the question was, what key evidence can we provide? Well, some key evidence is we need to have a quantifiable economic impact. What I mean there is we need to show the job creation, the impact, the benefit to the GDP. We also need to show that our applicants that they have industry recognition and they have endorsements within their industry. And we need to show specific examples of how their work aligns with the U.S. priorities, which we see as going more toward infrastructure and other critical industries like healthcare, like technology. That is some of the key evidence that we will have to show to show that these applicants will contribute to the U.S. national interest.
One more thing I want to interject, Rajni, is that we've kind of taken a tact on our EB-2 NIW cases, treating them almost as if they're EB-5s. So we like to see at least 10 direct job creations under the business plan. And then we also want to show at least some significant impact on what's called the TEA type zones, the high unemployment, rural, those areas, because those are what, in the government's mind, those are, kind of policies that they want to address. We're trying to use that mindset from over here in the EB-5 world, implement that into our EB-2 NIW cases to kind of make that extra link on the national interest. Say, hey, not only is our person going to do XYZ resulting in DEF, but look, they're also going to create 15 jobs, 20 jobs, direct jobs, which will result in a downstream of 75 jobs, and they're going to help rural or economically disadvantaged or high unemployment areas in this way too. So we're just kind of having to try to get sophisticated, a little more sophisticated, and change the way we think about and approach these cases to kind of try to outthink the adjudicator, if you will. I don't know. It's, if you try the same thing and get the same result, then that makes no sense, right? We want to get ahead of the game.
Okay. Well, thank you for the answer, Rob and Philip. And Rob, you mentioned Elon. So I really hope that, he actually takes the national interest to the next level, but doesn't dodge it.
There's things that need to be dodged, Rajni. Believe me, I was inside the belly. That could be helpful to us in the long in our interest and your clients' interests. So anyway.
Yeah, that could also happen. So, but Philip, I would like to come to you, and I would like to ask you. But what about the applicants? In the fields outside STEMs, like maybe arts or social sciences. How can they stand in their case to potentially the stricter definition?
Sure. Well, so applicants that are in the STEM fields, if we're thinking more, which I think USCIS and immigration law on a whole is going toward more of a merit-based system. We know we're pretty certain that under the Trump administration, it's going to be more merit-based. And so taking that into account, and taking into account the effect that might have on applicants that are in the arts or the education or social sciences, I think what we need to do is we need to have a clear, measurable benefit to the U.S. interests. We need to show evidence of these applicants' exceptional ability, and we need to show their national awards, their publications, their broad societal impact, how they're going to help the U.S. national interest. And so really the analysis is the same as any, STEM versus non-STEM, but we may just have to go deeper. As Rob mentioned, a key part is preparing this case as if we're applying for the big EB-5 visa. And for anyone who doesn't know what that is, that's the big investor visa where an applicant needs to invest a minimum of $800,000 and needs to provide or create at least 10 U.S. jobs. That's a high threshold. And so I think part of the success that we've had with the EB-2 NIW petitions is that we take that framework and we try to apply it to these applications that have a lower threshold. But if we can hit that higher threshold, then that's great. And I think that's part of why we've had, and not just us, other immigration attorneys have been doing the same thing. But that's how we would show that a non-STEM applicant can contribute to the U.S. national interest and be successful with an EB-2 NIW petition.
But so, like, if you had somebody in the arts and social sciences, you just got to think, okay, what's the major problem? All these wars we've had in Afghanistan, all these soldiers that we've had come back with PTSD, part of their plan is going to be, we are going to go out into the veterans community and help kind of, rehabilitate and I don't know what the word is I'm grasping for, but kind of ease the pain of these soldiers through the use of our art program or our social
basically like coping mechanisms.
Social sciences, sciences, yeah. So you got to think about how you're going to tie what would otherwise be, hey, this is just a great artist, this will improve our culture. If it was me, I would say, yeah, we're going to do that. But they're also, like, I'm just making this up, we're also going to help all the veterans with PTSD because we're going to go out to them, do outreach to them as a way to help them ease and recover, from the pain, mental pain that they have still from being in war.
Yeah. Mm-hmm.
Gotta get creative.
Mm-hmm. Yes, Rob, you were saying.
You have to be creative. You're just going to have to get very creative in those specific areas. It's not going to be good enough, I don't think, just to say, oh, I'm great at social sciences or great at art. You got to think about doing some other things and tying in some other aspects that you normally wouldn't do, but that are important to the Trump administration.
Right. Okay, thank you so much for that insightful answer. Well, we really hope that national interest, doesn't become, whatever that makes USCIS less bored today. It doesn't change to that because, that also happens, right? So thank you so much for that insightful and detailed answer, Rob and Philip. Now, a lot of people are actually posting their questions. So before I take my questions, how about if we move to the viewers' question?
Sure, whatever. It's your show. You tell us what you want to do.
Thank you so much. Okay, Andre is here and he says, I am Brazilian, and he says hello from Brazil, and he says this rule is not God or good. I'm not sure what he means by that, but Okay, let's take Asim's question maybe. So Asim says, one of my friends applied for an EB-2 NIW visa last year and got denied. He's now thinking of applying again, but the process seems more complicated with the new guidelines. Do you think the new rules are making it harder to qualify? And if so, what different should be done to qualify? Rob, let's start with you.
Well, like we said before, Andre, the rules haven't changed. The way you approach the rules, you may need to change your approach because you don't see it. Your Brazilian friend doesn't see it because they just were a one-shot player, right? They just came up to the plate, they swung 3 times, and they struck out. You can retool those same cases, but use a firm like Rajni's or us or whoever you want to hire and rethink as to how they're being adjudicated now. What can we change differently? What can we change in your business plan? What can we emphasize more? And what different national interests can we try to hit and link to in a different way and maybe amplify the impact of your proposed endeavor so that you will be successful this time? Resubmitting it the same way you did it last time, you're going to get the same result, right? But the rules have not changed. The way they're implementing the rules have changed. So you got to stay current with that. You got to stay in the mind of USCIS. You have to stay, have your pulse, your thumb on the pulse of how they're adjudicating, not just your cases, not just Rob and Philip's cases, but the whole nation's cases. Mm-hmm. And it's not something that a layperson would know because they're just, just throwing it in there.
Yeah. We've got to. I agree with Rob. The guidelines haven't necessarily changed. The bar has moved a little bit higher, but again, EB-2 NIW is not an easy visa to qualify for. Yeah. We often tell our clients that it is a superhero visa. We need to show how they are going to be a superhero to the U.S. interests. Mm-hmm. And so if it didn't work the first time, that's okay. We wouldn't discourage you from trying again if you can do it in a creative way where you can really bring to the forefront and highlight your experience, your knowledge, your record of exceptional ability.
Okay, thank you so much for that great answer, Rob and Philip. Asim, I hope you have got your answer. In case you're looking for a follow-up, continue posting it in the comments below. Meanwhile, let me quickly take Sanjay's question too. Sanjay says, I have been told that supporting documentation plays a crucial role in the EB-2 NIW process. Has the evidence required changed with the recent updates from USCIS? And if so, what kind of documentation is now essential? Philip, would you like to answer it?
Sure. I think documentation and providing the key evidentiary documents is key. It is key to an EB-2 NIW application. And the biggest one is a professional business plan, a business plan that outlines every single aspect of the applicant's proposed endeavor. We need to show that they will contribute to the national interest of the U.S., that they will have a substantial impact, that they are that they're well placed to follow through and execute their endeavor. Okay, so a business plan is key, and maybe not stop there. In several of our cases, what we've done is, sure, it's a requirement. Any client that we work with, it is a requirement that they submit a professional business plan that is prepared by an independent company who looks at our applicant's record, CV, and is able to interpret that is able to create a professional business plan based on that record. However, again, we don't necessarily need to stop there. We can provide expert opinions. So in several cases, we have gone out and looked for U.S. experts on the particular industry or topic that the applicant would like to apply based on, and have those experts explain how the proposed endeavor would impact the U.S. national interest, how it would improve, how it would bring significant benefit to the U.S. interest.
Yeah, the average, to answer your question on paper, our average filings in these cases are minimum 500 pages up to 700, 900 pages. Okay, so yeah, documentation is important. There's critical pieces that Philip's already mentioned. Number one is the business plan. Number two is if you're advanced degree, obviously you have to show that. If you're not advanced degree and you're going for exceptional ability, you're going to have a ton of documentation to prove up because you're going to have to hit 3 of the 7 requirements, and you're going to have to do those through letters of reference, colleagues or people highly positioned within the government, business or academic sectors, as high up as they can, but they got to know you. They got to know your past accomplishments and what were the outcomes of your efforts, and then also give a really strong prognosis of your future, your potential, your potential energy, so to speak, because these aren't letters of you should give XYZ a job because they're a great person. No, these are letters of hyperbole, like to the maximum. This is the best person I've ever known. They resolved all these problems for this industry. It had an impact on the actual industry overall. And wow, what a great day when they become a U.S. resident, because they have the potential to take their proposed endeavor, shoot it to the moon. So yes, minimum. Business plan, letters of recommendation, and then all your paperwork you need to back up either your extraordinary ability or just your master's or PhD or your bachelor's plus 5 years advancing professionally in your area. And the thing I like about the expert opinion letters, those are kind of silver bullets. I mean, that doesn't mean you're going to win because of it, but they are very impactful because they are from industry experts in your area of expertise, totally independent. They don't even know this person. They're just reviewing the record and writing a professional opinion. Many times the CVs that they attach to theirs are like 20 or 30 pages long themselves for that particular expert. So, I mean, these are heavy hitters. The other thing I want to tell you is expect an RFE. You're going to get an RFE on everything. Oh my goodness, I got an RFE. I have a horrible case. I thought you guys said I had a strong case. That's not what they're doing. They're beating you down by attrition. So don't give them all up front, right? One of the strategies is to just hold back a little in anticipation of the RFE, because then when they bring the RFE, you still have some bullets in your gun that you can fire at the RFE, plus maybe go to some of these extraneous sources like an expert opinion letter.
Okay. Thank you so much for that answer, Rob and Philip. So no nepotism. It will all depend on the skills and right. So Sanjay, I hope you have got your answer. So make sure that you have all those documents ready that were mentioned by Rob and Philip, and you have to keep in mind that the nepotism will not work, especially not anymore. And yes, Rob is nodding. He is completely against it, right, Rob? Especially with the EB-2 NIW visas.
If you're talking nepotism as far as like reference letter, hey, if you can get a reference letter from Trump, you get that reference letter. We've had cases where we've gotten reference letters from presidents of other countries for the national of that country. So don't shy away from that. But it can't be just, hey, this is my niece or nephew, let them in. They got to know your professional abilities, your professional history, and your potential. So they got to speak professionally to that. It can't just be, well, Rajni's a great person, so she should really be a resident. It's got to have some depth and substance to it.
Absolutely. And I think that's the reason why President Trump also endorsed, he said now if you are skillful and if you are adding to the US's economy, you will be eligible to get the green cards. And no longer because you are applying and because you are in the wait lines, you'll be able to get the green cards. Only you are skillful, and if you are, getting graduated from the good universities of the United States of America, you'll be eligible to get the green cards. Is that why he also endorsed that, Rob?
Yeah, I believe so. I think, I mean, I just read an article, it was a Politico, right?
Mhm.
Which is no friend of Trump or anybody on the right.
Right.
Yeah, so far left article basically saying, look, they are going to be looking for people with skill sets, especially in STEM. And sorry, I got a little off track. What was the question? Rajni, what was it?
No, even I forgot. I was too invested in your answer. Even I forgot what I was asking. But actually, is that the reason why actually Trump endorsed, the skills?
More of a merit-based system. And in reality, I'll let you go ahead and finish your talk on the article.
Yeah. So the article was saying, look, Trump is an Indian national's best friend because they have the skills, they have the intelligence. They're going to bring, they're going to bring the heat on the areas that he wants. They anticipated the biggest pushback is maybe a problem with Congress getting heat from their constituents because we've had so many problems in the U.S. with irregular immigration that I think people kind of got fed up with immigration and lumped it all together, whether it's legal or, irregular. And so Congress might be more of a problem than Trump and his cabinet. But yeah.
Yeah, and the thing with the merits-based system is, I think the benefit that I see to the way it's being laid out, or we anticipated it will be laid out, and how it was laid out during Trump's first administration is, I believe we're dealing with the merit-based immigration system as is. At least under the administration, is they're giving you the guidebook, they're giving you the blueprint. Here are the 10 items that we're focusing on, and here's how you can qualify under each of those 10 items. Whereas to me, it may be a little bit more laid out, a little bit more transparent versus what USCIS may have been doing in the past, where it seems more discretionary, right? So if it's more discretionary and USCIS decides, well, we'll put more weight on this one item versus this other item, a merit-based system that is clear, that is transparent, could do a lot of good for visa applicants who do qualify, as Rob mentioned.
It might be bad for us as attorneys because it won't be as complicated, but I think it's much better for the clients.
Yes,
because they maybe just have a scorecard, right? And I don't know. I think it's going to be good for a lot of people groups around the world. Others not so much, but for certain people groups, definitely.
And of course, and that's how it should be, right? If you have those skills, and if you are a merit-based person, and you should be eligible to get the green cards, and if you're adding to the US's economy, you should be eligible, to get the green cards. Whereas, but then, talking about Trump, that's a whole another conversation, because then what he sometimes says, then his actions are, completely against what he's saying, because, he wants to have the merit-based system for the immigrants. But then coming to his own team, he's picking Linda McMahon as the Secretary of Education Department. So, I mean, that's a little controversial, right? Rob and Philip, I mean, I know that's a conversation for...
Yeah, Rajni. He's a non-traditional politician, but still a politician at the end of the day.
True.
I won't defend him on that, but I do like Kash Patel and Vivek. I'm not gonna apologize for that.
Well, even I not just Kash Patel and Vivek Ramaswamy, but even Tulsi Gabbard and then Stephen Miller and then Tom Hooman as the border czar. I think those are some great picks, right? Whether you agree with his policies or if you disagree with what he says, but then some of his candidates are really amazing. And thank you so much, Rob and Philip. But I would again like to maybe take a few more questions. Hari is here and he has posted a question from LinkedIn. He says, I'm eligible to apply for this is actually for an H4 EAD. So would you like to take this?
No, we really shy away from giving case-specific advice to a non-client for ethical reasons. We don't know the facts behind their. If you want to speak generalities, it's fine, but maybe this one's not the greatest one. Yeah.
So maybe, Hari, what you can do is the details of Rob and Philip are scrolling below. You can directly, if you want to get in touch with them, you can get in touch with them, discuss your case with them. And yes, I'm more than happy to help you out, and you can, directly write to them. And let's quickly take Madhavi's question. Madhavi says, can you analyze the recent USCIS policy changes and court decisions impacting EB-2 NIW visas and provide specific examples of how these changes have affected the approval rates and processing times for NIW petitions?
Well, I'll start. So sure, as far as the new cases, and so the biggest case that we've seen come out with EB-2 NIW is the matter of Danisar case. That's what provided the three prongs that we've been discussing all along that gave it a more streamlined approach to the pre-Danisar era, which was guided by another case, New York State Department of Transportation, which that required, it was a little bit tougher under that standard because what it required was proof of national scope and specific labor market unavailability. That was challenging for many applicants. And so what Danisar did in 2016 is it now focuses more on substantial merit and national importance. So we were talking about work by an applicant that it has inherent value and can be important to the U.S. interests. So what we've seen is a shift from the focus of market unavailability to the applicant's unique contributions to the U.S. And how I think that has affected the EB-2 NIW petitions is it has like we were talking about with a merit-based system, it is laid out. Now you have a playbook with specific guidance as to how you can meet those requirements and have a successful visa application. And what we've seen is there has been an increase in the rates of approval. It's still a tough visa, but we think now we have a clear standard under which to apply.
As far as the court decisions that was mentioned in the last question, one thing that I see all the time on our distros, one thing to keep in mind, the NIW piece is completely discretionary. Completely discretionary. You cannot challenge that in federal district court, the U.S. Supreme Court, whatever. You will get knocked out at the knees immediately on a motion to dismiss your case. So if you lose your EB-2 NIW case and you want to fight them in court, for wrongfully denying your case, and if they made that decision based under the NIW piece, it's a loser case, we call it. So if there was other key legal factors in the EB-2 qualification part, you may have a case to go forward. But the NIW piece itself, it's in the adjudicator's hands. I don't remember the name of the case, but there was a recent case that came out speaking to vice consul, the inviolability. I always have trouble saying that word. It's inviolable. You can't violate the vice consular's decision, right? They're the judge, jury, and executioner in let's just call it the B1, B2 context, but really in adjudicating consular process cases. This recent case that came out totally strengthened that position. Before, there was a lot more challenges you can make to the consular decision, the vice consular decision-making process. But now they've been narrowed down tremendously, which was weird because just before that, there was a case coming out limiting administrative, the Chevron case, limiting the administrative ability of agencies to basically legislate upon, us. So, but since we're specifically talking about this concept, the cases are against any type of appeal to a district court in a federal lawsuit context.
Yeah.
It'd just be a refile would be your.
Yeah, and just to add to part of the question was how has it affected processing times? We've seen shorter processing times in general for EB-2 NIW. As a matter of fact, right now, as of this morning, we're looking at 10 to 13 months processing time for the Form I-140 for an EB-2 NIW case. And then, of course, you think if you do premium processing, which we've discussed some pros and cons about that, then you're looking to a shorter time period of 15 days. So what DataSart has done is it's created a clearer path to the EB-2 NIW visa.
If there's one thing I could add to, when we file our cases, we always put for consular processing, even though we hope we don't have to, because you can always adjust status even if you put consular processing on the petition. All you have to have is your receipt number for the approved petition. And if you have a legal way to stay in the U.S. And your case and your category is current, then you can adjust status from within the U.S. If you have to run the gauntlet of consular processing, you're basically going to get re-adjudicated again by the vice consul. You already got adjudicated by the USCIS officer. But that's not the biggest issue. The biggest issue is got to run through NVC first in Washington. There's going to be administratively a couple months to get you documentally qualified. And then they just wait. And they wait for post to have an interview available for you. We have cases that have been ready for interviews since September 2023 and still have not had an interview date yet in that country. And I don't know what the case is in India at the embassies or consulates there, but in general, I think they're taking low priority on scheduling interviews versus the relative family member immigrant visa, which is means the most to Congress because that's the people that vote for them,
Right. Okay. Thank you so much again, Rob and Philip, for answering the question. Let me quickly take Trisha's question because she has also posted one question over here. She says, I'm considering submitting a waiver of job offer for the EB-2 NIW visa, but I'm uncertain about how USCIS is viewing these types of cases under the new guidelines. Can you explain how they assess the waiver and what strategies might help to improve the approval odds in this area? Philip, let's start with you.
Sure. Well, with the NIW, of course, as we know, the benefit of applying for EB-2 NIW is to waive the job offer, going through the perm process, which is, time consuming, a little bit, more expensive. So what we have to do is we have to show why it's in the best interest, why it's in the national interest to waive the job offer. And explanations of how the way we do that is we need to show that waiting for the job offer is not feasible or practical for this particular endeavor, for the proposed endeavor. We need to show that the applicant's skills and expertise, that they're highly specialized and they're not readily available in the U.S. workforce. That's another way to do it. And finally, a third example is we have to explain how waiving the job offer would accelerate the project's progress. If you make this applicant wait the 2 to 3 years, you're delaying this really important work that they can do in the U.S. So if you waive that job offer, what you're doing is you're accelerating that progress. You're accelerating the benefits that this applicant is going to bring to the U.S.
One other thing along that line on the whether or not it'd be in the best interest of the U.S. to waive the labor cert is to hit if you have a case where it's impracticable, like say this person, if they take a job offer at a certain place in this industry, will have a non-compete clause automatically because that's the industry standard. So they won't be able to benefit the industry as a whole. They will be pigeonholed into one specific employer, which will not help the national interest. So therefore, it's in the U.S. best interest to waive the labor cert. Or this person holds a patent on a widget that, it's impracticable because they own the patent, on the widget, and, no one else is going to get it. So let's bring them in and let's get them started and let's get them helping the U.S., thrive.
Okay. So, Trisha, thank you so much for your question. I hope you have got your answer. Now, Rob and Philip, there are a few questions posted in a Facebook group by our viewers. So, if you don't mind, can I share my screen and maybe take some of the questions from there?
Sure.
Great. Thank you so much. Okay, I'm quickly sharing my screen. Okay, can you see the screen? Okay, so this person, I think Javier, has posted that he says, I'm a Spanish teacher. I have applied for EB-2 NIW I-140. Does anybody know if there is any possibility to be approved? What would you like to say?
I would say no, because there's no such thing as an EB-3 NIW.
EB-3. EB-3. Yeah, we assume she meant. I'm going to assume she means EB-2 NIW, and we like to say that no case is impossible, right? We would need more details, but speaking hypothetically, a Spanish teacher isn't automatically ruled out from an EB-2 NIW. However, what we discussed earlier, you've got to be creative. We've got to show what experience does she have? How would she benefit the U.S.? In the U.S. here, we're dealing with an ever-increasing Hispanic population, right? And unfortunately, sometimes a lot of the Hispanic population is in underserved communities where someone like the caller, the questioner there, could potentially benefit the community. We have to show how does her experience as a Spanish teacher improve the U.S. economy, U.S. national interest. So again, we don't like to say any case is impossible. That could potentially be a tough case, but it's not impossible.
Yeah, I think if she's got especially if she can hit the advanced degree portion, I think with some creativity and a good business planner, you can easily weave that into a strong national interest argument because of the just like Philip said, the segment of our country right now of the Latino segment is humongous. Yeah.
Or maybe having the right attorney might help in cases like these, right?
Sure, that is key. Having the right legal team at your side to help you navigate something that complicated.
Right.
Yeah.
So,
sorry.
No, please go ahead, Rob.
Identify the need and then connect the dots. That's what you got to do. Identify the national interest and then connect the dots in the proposed endeavor. It's just very explicit, and that one alone, I think I could come up with about 35 different ways that we could make a strong argument on her behalf.
Well, Javier, if you're looking for an attorney for yourself, maybe get in touch with Rob and Philip. The details are scrolling below, so you can note them down. And we are also going to, I'm also going to read out the details for you. So if you are looking to get in touch with Rob, you can give him a call on the number 512-293-3023. I would like to repeat the number, 512-293-3023. You can also email him. His email ID is robmelvin@melvinlawgroup.com. Rob Melvin at melvinlawgroup.com, and his website is www.melvinlawgroup.com. And if you're looking to get in touch with Philip, you can give him a call on the number, which is 979-776-1325. I would again like to repeat the number, 979-776-1325. 1325. You can also email him. His email ID is Philip, PHILIP at dosrodlaw.com. Yes, and you can also visit Philip's website, which is www.philiprodlaw.com. So make sure to get in touch with Rob and Philip. They'll be able to help you with your case. I know it will be a little complicated and a little tough in comparison to others, like Rob and Philip mentioned, but they are the experts and they are surely going to help you. Thank you so much.
Just to let your viewers know, Rajni, both of those telephone numbers for Philip and I are also WhatsApp numbers. So if you have any WhatsApp users out there, they can send WhatsApp messages through those channels.
Well, perfect. What's better than that? Rob and Philip are just a WhatsApp message away, guys. So get in touch with them right now. Right. And also, I have one question which was actually posted 2 hours back, and it is from a girl named Kripa. And she says, I have an approved I-140. I'm waiting to file my I-485. My current employer told me that they won't file my I-485. Can I change my employer for I-485?
Well, Kripa, it's not clear what visa you're talking about there, unfortunately. Because what we're discussing is an EB-2 NIW visa, which does not require an employer. So maybe some clarification would be helpful. As Rajni mentioned, if you'd like to, you can reach out to us, offline, and we can get some more information about your particular situation and do our best to answer your question.
Perfect. Let me take one last. Rob, Tamar says, does the premium processing affects the approval percent in the EB-2? What do you have to say?
Back when I was young, it was the $64,000 question. Now it's the $64 billion question, right? Depends who you ask. I know some very well-seasoned attorneys, immigration attorneys, that have done tons of EB-2 NIWs. They say premium processing is the biggest joke, the biggest waste of time, and it's just a throwaway of money. I know others that say it will actually prejudice you because you're putting heat on them. Remember, these are bureaucrats. I was a bureaucrat. You want to do the least amount of work that you can to get the day over so you can draw your check and build your pension. These are not go-getters. If they can kick you back an RFE in a premium processing case and then kick the can down the road, it's probably what's going to happen. I can't say it with 100% certainty that it will prejudice you. I've heard others speculate that it will. My opinion is they're worthless because of the retrogression. So why, unless there's some insane pressing need to know the answer in 45 days that I would be glad to discuss with anybody offline. We try to talk our clients out of using it. Some people were so afraid of Trump winning that they insisted we used it. We used it, and they had to go through all the same stuff that anybody else had to go through. Thank goodness they were approved.
Yeah, and let's think about what premium processing does. What Rob mentioned is USCIS. You can't blame them. They've got a lot of work on their desks. And what we're asking them to do with premium processing is cutting down a 10 to 13 month process into less than 45 days, 15 to 45 days. You've got to think about what that does. If we had a project that normally takes 10 to 13 months and we had to cut down that short period of time, they may have a lot of questions. And so what that may lead to is a request for evidence. So again, you're going to get a different answer based on who you ask, which immigration lawyer you ask. But yes, in some cases, maybe premium processing is the way to go. But what we have seen is in the majority of cases, it may not be the value that people think it is.
In that vein, of all the comments I've heard on premium processing, and I've heard hundreds, if not thousands, I have never heard somebody jumping up and down saying, yay, I'm so glad I chose premium processing because it was so wonderful, and it was so beneficial to me. Not once.
Mhm. But Rob and Philip, people are so scared of RFEs. As soon as they get the RFE,
They're
they
coming.
panic and go into that chaotic zone and chaotic mode. So, but RFEs can sometimes also be helpful for their cases, right? So, in situations like this, how should they deal with? I mean, what should they do, and how should they deal with that?
As Rob mentioned early on, you go into, and we always explain this to our clients, potential clients early on, you have to go into it expecting an RFE, right? What we're proposing for our clients oftentimes is a very complicated endeavor. They're highly specialized, they're highly skilled. So there are going to be questions about the process. So we tell our clients an RFE is probably going to come, just expect it. What we do is we're going to be ready with additional evidence if we need it. For example, Rob mentioned the expert letters earlier. Those aren't required in the initial submission. They're not required. The business plan in most cases is sufficient. So sometimes some clients, in order to preserve resources from the initial submission, may say, let's not submit the expert letters right now. Let's submit the business plan. Let's submit the best initial submission we can. And if and when we get the anticipated request for evidence, well, then we provide that additional evidence. Like Rob mentioned, we keep a little bit back just so that we can respond effectively to a request for evidence and provide a clearer picture to USCIS of what our client is trying to do. So again, the takeaway is, in this visa category, a request for evidence is likely to come. Just be aware of that up front so that you're not surprised by it when you get it.
The only case that I can remember us having where there was no RFE was the proposed endeavor had a direct impact on the amount of filing fee income generated to USCIS at an exponentially humongous amount. For some reason, that case sailed right on through without any RFE. It was amazing.
Yeah.
Well, I think that's a great way to actually put it. You should go with the expectation that you will get an RFE. I mean, expect the worst and you will never be disappointed, how they say it, right? But thank you so much, Rob and Philip. It was so great having you both on our channel and on our show, Immigration and Jobs Talk Show. We had an amazing show. We were actually supposed to have this for an hour, but we actually did it for an hour and a half, and we didn't even realize it. So thank you so much for being here. And even after doing it for so long, we couldn't even cover half of the questions that we actually planned for you. So maybe how about we do another episode on the same topic and we get into the depth of it.
Anytime.
Perfect. So guys, if you're looking to get in touch with Philip, you can give him a call on the number 979-776-1325. His email is philip@dosrodlaw.com. His website is www.philiprodlaw.com. So make sure you give him a call, WhatsApp him, email him, and also check out his website. And if you're looking to get in touch with Rob, you can give him a call on the number 512-293-3023. His email is robmelvin@melvinlawgroup.com, and his website is www.melvinlawgroup.com. So make sure to get in touch with the both of them. And like they said, their numbers are also available on WhatsApp. So make sure that you also send them a text on their WhatsApp numbers. They are just a text away. So again, thank you so much, Rob and Philip, for being here. Any closing note from the both of you?
No, thank you very much for having us on. It's been a pleasure. It's an honor to be on this show. We know you have a lot of viewers. We know that your show is putting out a lot of good information to all of your viewers, and we're honored to be a part of it.
My only thing to say is, India, keep your chin up. It can only get better, and I think it's going to get better for you. I think you have a lot more people in your corner than you think you have, and I am very hopeful for you, not only just in the EB-2 NIW category, but also hopefully bringing down the retrogression numbers and the weight that you have for your visas or your adjustments of status. So keep your chin up. Let's keep in there. Let's keep fighting. And we're here to help you out.
Thank you so much. Thank you so much to the both of you. Can't wait for the both of you to be back on the show with our next episode. And thank you so much again for being here. You both have a great day ahead.
You too.
Thanks. You as well.
Ciao. Thank you.
Guys, thank you so much for tuning in, and thank you so much for posting those amazing questions in the comments below. You can continue posting them whenever Rob and Philip are going to be back. Maybe we can take those questions and ask them in the second episode, or whenever they are back for the next episode, or maybe we can get in touch with them, write to them and get a reply from them, and we will post the reply in the comments below. So you make sure that you are continuously posting your question in the comments below. But for now, I'll have to take your leave. But you make sure that you are always tuned in to Immigration and Jobs Talk Show. So stay tuned with Immigration and Jobs Talk Show for every immigration update. I'm Rajni Bharara, your host, signing off for now. I'll see you very soon. Bye. Keep watching and keep subscribing.
Bye-bye.
Bye.